Right now, millions of Americans are paying debts that are no longer legally enforceable. They are answering calls they do not have to answer. They are handing over money to collectors who in many cases are breaking the law just by the way they are contacting them. And the only reason this keeps happening is because nobody ever explained how this system actually works. Every source cited in this video is linked in the description below and listed at the end. Everything comes directly from federal law, the Consumer Financial Protection Bureau, and the Federal Trade Commission. In the next few minutes, I am going to walk you through exactly what happens when you ignore a debt collector. Not the vague warnings you find on the first page of a search engine, the actual legal process, step by step, including the specific federal laws that protect you, the one letter that can force a collector to stop collecting until they prove the debt is real, and the exact actions you should take if a collector reaches out to you today. By the end of this video, you will understand 4 things most people never learn. First, what debt collectors are legally allowed to do and what they are absolutely prohibited from doing under federal law. Second, what actually happens if a collector sues you and you do not respond. Third, the exact letter you can send that legally forces a collector to stop all collection activity until they prove the debt is real. And fourth, whether your debt has an expiration date and what that means for you. None of this is legal advice. I am not a lawyer, but everything in this video comes directly from the Fair Debt Collection Practices Act, the Consumer Financial Protection Bureau, and the Federal Trade Commission. Here is the first thing most people do not realize. The person calling you is almost never the company you originally owed money to. When you stop paying a credit card, a medical bill, or a loan, the original company will try to collect for a while. They will send letters, they will call, but after a few months, most of them give up. They do not forgive the debt. They sell it. And this is where things get important. They sell your debt to a third-party collection agency, often at a steep discount from the original balance. The collector then tries to get you to pay as much of that original amount as possible. The difference between what they paid for the debt and what they collect from you is how they make their money. This matters because the collector is now what the law calls a third-party debt collector. And third-party debt collectors are regulated by a specific federal law called the Fair Debt Collection Practices Act, or the FDCPA. The law defines a debt collector as a person or company whose principal purpose is the collection of debts owed to another. This law gives you significant rights. Most people have no idea those rights exist, and collectors are counting on that. Once you understand that the person calling you is not the company you originally dealt with, but someone who bought your debt at a discount, it completely changes how you think about those calls. Let us start with what they can do, because their powers are more limited than most people think. Under the law, a debt collector can contact you by telephone, mail, email, text message, and even social media, though social media contact must be sent privately and cannot be viewable by the general public or your contacts. They can report the debt to the 3 major credit bureaus, which can lower your credit score. They can offer you a settlement for less than the full amount. And importantly, they can sue you in civil court to try to collect the debt. That last one is the big one. If a collector sues you and wins, a court can authorize them to garnish your wages or freeze your bank account. We will come back to exactly how that works in a few minutes, because most people lose that case for a completely avoidable reason. But here is what matters right now. Everything on that list requires them to follow the rules laid out in the FDCPA. The moment they break one of those rules, they have violated federal law, and you can actually sue them. Under the FDCPA, debt collectors are prohibited from doing the following, and these are not suggestions. These are federal laws with real penalties. They cannot call you before 8 in the morning or after 9 at night in your local time zone. The law specifically defines this as an unusual or inconvenient time. They cannot call you more than 7 times within a 7-day period about the same debt. And once they actually speak with you on the phone, they cannot call again for 7 days. They cannot threaten you with arrest. They cannot threaten you with jail. If a collector tells you that you will be arrested for not paying, they are breaking federal law. The FDCPA specifically prohibits the representation or implication that non-payment will result in arrest or imprisonment, unless such action is lawful and the collector actually intends to take it. They cannot use obscene or profane language. They cannot threaten violence or harm to your person, reputation, or property. They cannot call your workplace if they know or have reason to know your employer prohibits those calls. And they cannot discuss your debt with anyone other than you, your spouse, your attorney, the creditor, or a credit reporting agency. They can contact other people, but only to locate you, and generally, only once. They can't tell those people that you owe a debt, and here is one that surprises most people. They cannot threaten to take legal action that they do not actually intend to take. The FDCPA calls this the threat to take any action that cannot legally be taken or that is not intended to be taken. So, if a collector says they are going to sue you, but they have no intention of actually filing a lawsuit, that threat alone is a violation of federal law. Federal law gives you specific, enforceable rights. You just have to know they exist. If a collector violates any of these rules, you can file a complaint with the Consumer Financial Protection Bureau or the Federal Trade Commission. You can also sue the collector in state or federal court. The law allows you to recover any actual damages you suffered, plus additional statutory damages of up to $1,000 per lawsuit, plus your attorney fees and court costs. And you do not have to prove financial harm to receive the statutory damages. This is the part that changes everything for most people, and it is the reason you should never completely ignore a debt collector. If a debt collector decides to sue you, you will be served with a court summons. That summons will tell you exactly when and where to appear, and it will give you a specific deadline to respond. Here is what happens if you ignore that summons and do not show up. The court enters what is called a default judgment. That means the collector wins automatically, not because they proved you owe the debt, not because a judge reviewed the evidence, simply because you did not respond. Default judgments are extremely common in debt collection cases because many consumers do not appear in court or respond. Once a collector has a default judgment, they can petition the court for wage garnishment. Under federal law, specifically Title III of the Consumer Credit Protection Act, a collector can generally garnish up to 25% of your disposable earnings. Disposable earnings means the amount left after legally required deductions like federal, state, and local taxes. Some states set lower limits than the federal standard, and when state and federal limits differ, the law that results in the lower garnishment amount applies. A few states have very strong protections. For example, Texas law prohibits wage garnishment for most consumer debts entirely, limiting it to child support, taxes, and student loans. South Carolina law similarly prohibits creditors from attaching unpaid earnings by garnishment for consumer credit debts. They can also freeze your bank account and take money directly from it to satisfy the judgment. This is called an account garnishment or bank levy. Once the court issues the order, the bank is required to freeze the funds. You do receive notice, but by the time you see it, the account may already be frozen. Federal law does protect certain benefits. Banks must protect 2 months of directly deposited federal benefits, including Social Security, veterans benefits, and federal student aid, before freezing or garnishing money in your account. This entire chain of events, the judgment, the garnishment, the frozen account, starts with ignoring the summons. If you show up, if you respond by the deadline, you can challenge the debt, request proof, and depending on the situation, get the case dismissed or settled for less. The default judgment only happens when you do nothing. If you take one thing away from this entire video, let it be this. When a debt collector first contacts you, federal law requires them to send you a written notice within 5 days of that initial communication. That notice must include the name of the creditor, the amount of the debt, and a statement that you have 30 days after receiving the notice to dispute the debt. That 30-day window is your opportunity. Within 30 days of receiving that notice, you can send what is called a debt validation letter. This is a written request that tells the collector, prove that this debt is real, prove the amount is accurate, and prove that you have the legal right to collect it. Here is why this letter is so powerful. The FDCPA states that once the collector receives your written dispute, they shall cease collection of the debt until the debt collector obtains verification and mails a copy to you. That means no more calls, no more letters. Collection activity stops until they provide written proof. If they do not have sufficient documentation to verify the debt, they cannot legally continue collecting. This is particularly important when dealing with debts that have been sold and resold between multiple collection agencies, where documentation can become incomplete or inaccurate along the way. The idea that one letter sent within 30 days can halt the entire collection process until they prove the debt is legitimate. That changes the entire dynamic from feeling powerless to having a real tool you can use. One critical detail: the Federal Trade Commission recommends sending this letter by certified mail with a return receipt requested, so that you have a record the collector received it. If they continue collection activity after receiving your validation request without first providing verification, that is a violation of the FDCPA, and you have grounds for a legal complaint or a lawsuit. There is a free debt validation letter template linked in the description below that you can download, fill in your information, and send today. There is one more thing you need to understand, and it might be the most important piece of all. Every state has what is called a statute of limitations on debt. This is a specific time period after which a collector can no longer file a lawsuit to force you to pay. The statute of limitations typically begins when you miss a payment on a debt, though in some states it may be measured from the date of your last payment. After this period expires, the debt is considered time-barred. Here is what is critical to understand. A time-barred debt does not disappear. Your obligation still exists on the books. Collectors can still contact you and ask you to pay, but they lose the legal ability to force you to pay through the courts. Under the law, it is illegal for a debt collector to sue you to collect a time-barred debt. The time frame varies widely by state. Some states set the statute of limitations as short as 2 years. Others go as long as 20 years. Most states fall somewhere between 3 and 10 years. It also depends on the type of debt. Written contracts, oral agreements, promissory notes, and open-ended accounts like credit cards often have different statutes within the same state. Here is the critical warning. If a collector contacts you about an old debt and you make even a small payment, or in some states even acknowledge in writing or verbally that you owe the debt, you can restart the statute of limitations clock. The debt is no longer time-barred. A new statute of limitations period begins, and the collector may be able to sue you for the full amount. Official guidance from the FTC is direct on this point. Do not admit to the debt. Do not apologize for it. Do not agree to a payment schedule, and do not make a payment until you have confirmed whether the debt is time-barred. A collector calls about an 8-year-old debt. You say, "Sure, I can send $50. And just like that, depending on your state, you may have reset the clock and given them the legal right to sue you for the full amount all over again. That is why understanding this rule matters so much. Here is exactly what to do if a debt collector contacts you. These steps are in order. Follow them. Step 1. Do not panic and do not ignore them. Consider talking to the collector at least once to find out if the debt is actually yours. But do not agree to anything. Do not confirm personal or financial information, and do not make any payments over the phone until you have the details in writing. Step 2. Request everything in writing. Ask the collector to send you written validation of the debt. If they have not already sent you a validation notice within 5 days of their initial communication, they are in violation of the FDCPA. Step 3. Send a debt validation letter within 30 days of receiving their validation notice. The Federal Trade Commission recommends sending it by certified mail with a return receipt, so you have proof the collector received it. A free template is linked in the description. Step 4. Check your credit reports. Go to annualcreditreport.com, which is the federally authorized source for free credit reports from all 3 bureaus. See what the collector has reported and whether the information matches. You can also monitor your credit score for free with a tool like Credit Karma. There is a link in the description. Step 5. Look up the statute of limitations for your state and your debt type. If the debt is past the statute of limitations, the collector cannot sue you. Do not make a payment or acknowledge the debt in any way because that could restart the clock. Step 6. If the collector continues contacting you after receiving your validation letter without first providing verification, file a complaint with the Consumer Financial Protection Bureau at CFPB.gov and the Federal Trade Commission at FTC.gov. Both links are in the description. And Step 7. If you receive a court summons, do not ignore it. Respond by the date specified in the court papers. If you cannot afford a lawyer, contact your local legal aid office or visit lawhelp.org to find free or low-cost legal assistance in your state. Showing up and responding is the single most important thing you can do to protect yourself. If you are watching this because a debt collector has contacted you and you did not know what to do, I want you to hear this. You are not behind. You are not irresponsible. The Fair Debt Collection Practices Act exists because, as Congress found when they wrote it, abusive debt collection practices contribute to personal bankruptcies, marital instability, loss of jobs, and invasions of individual privacy. That is not my opinion. That is directly from the congressional findings in the law itself. Now you understand how the system works, and understanding it is the most important step you can take. If a debt collector has already threatened to take you to court, or if you have already received a court summons, you need to understand exactly what happens at that hearing before you walk in. Many people lose their chance to fight a court order simply because they never show up or respond. But even when you do show up, understanding what happens at that hearing beforehand gives you the best chance of protecting yourself. I break down the entire process in this video right here. Hit subscribe so you do not miss it. And if this video helped you understand something you did not know before, drop a comment and let me know.